We shall now commence this module by studying the policy on research and development, patent laws and technology transfer. In today's dynamic world, there is no place for stagnant economies. Therefore, to survive in the world market, each business need to be very active in terms of research and development. Research is the new buzzword in business where each organization is striving to achieve something new and better than the competitor to attract new customers and retain the old ones. This chapter deals with the research and development policy of India and patent law as a legal framework for protecting the technology. This chapter will also explain the need of technology transfer and why technology transfer is important for the developing economy. After studying this module, you shall be able to understand the structure of Indian policy on research and development, gain knowledge about the Indian Patent Act, understand the legal aspects related to patents, analyze the concept of technology transfer and its modes, appreciate the role of technology transfer in economic development. Let us now discuss the policy on research and development. The economies of the present day world are driven by scientific research and technology. In India, the resolution on science policy was adopted in 1958 to put thrust in this direction and led to the foundation of a strong scientific and technological infrastructure in the country. It includes setting up of a change of national laboratories. Some of them are mentioned below. Council of Scientific and Industrial Research CSIR, Indian Council of Agricultural Research ICAR, Indian Council of Medical Research ICMR, Defence Research and Development Organization DRDO, Department of Atomic Energy DAE, Department of Space DOS, Department of Electronics DOE, etc. Apart from setting up of national boundaries also includes many other specialized R&D centers, universities, IITs and various academic institutions that continuously provide different functions like following: provide expertise, technical training to manpower, provide technological support to the industry. In the formative years, Indian industries were totally dependent on imports for technology and scientific and technological, which in turn facilitated rapid assimilation and indigenization of such technologies. Continuous measures have been enunciated with the time to meet the dynamic and continuously evolving industrial and technological requirements of a developing country like India. The objective of Science and Technology Policy 2003 was to achieve coordination between industry and scientific research, to encourage the transfer of technology and know-how generated by scientists and technologists to industry. The policy Science and Technology also encourages through innovative mechanisms investment by industry in education, research and R&D, either in-house or through outsourcing. As per the guidelines given by UNESCO, the Department of Science and Technology DST has been undertaking biennial national surveys on a regular basis since 1973-74 on resources devoted to scientific and technological activities. As per the Directory of R&D Institutions 2006 August published by the Ministry of Science and Technology, around 3,960 R&D institutions classified as follows: Central Government R&D Institutions 707, Public Sector includes only 150 in-house R&D units of Central Public Sector undertaking, State Government Institutions 834, Universities, deemed universities and 284 institutions of national importance. Private sector includes in-house 2020 R&D units of private sector industry and scientific and industrial research organizations SIROs recognized by DSIR total 3,960. Importance of R&D in India. Research and development R&D is an invaluable tool for growing and improving the business sector of a country. R&D involves researching market area and needs of customers to develop new and improve products to satisfy the needs of customers. Businesses having well-established R&D infrastructure and strategies have a better chance of success as compared to businesses that don't. A good and powerful R&D strategy can lead to innovation and increased productivity and can boost your business competitive advantage. Size of a business has great impact on the nature of R&D strategy as explained by figure given below. As you can see, in small business, there is focus on product improvement, cost and budget constraint. On the other hand, larger businesses, it requires introduction of new products and improvement in the existing ones. Large resources are available to conduct R&D activities. Due to budget and cost constraint, the small businesses normally focus on product improvements. On the other hand, as large businesses have the availability of huge financial resources, they can dedicate R&D activities for the creation of a new product as well as focus on the improvement of existing ones. One thing need to be understood by the businesses that spending too much money on R&D is not a guarantee of success. The key to successful R&D is extensive market research. Market research is a tool to identify the unsatisfied needs and want of customers. Moving on to the Patent Act. As per Patent Act 1970, patent is defined as a monopoly right which is granted to a person who has invented a new and useful article or an improvement of existing article or a new process of making an article. Patent gives an exclusive right to the manufacturer of article product for a limited period. Inventions can be divided into following categories. Product invention. When a new product or new alloy is invented, it is known as product invention. In this situation, patent is referred to as product patent. Next, process invention. When new process to produce a commodity is invented, it is known as process invention. This is referred to as process patent. Patent Act process patent and for product like food, pharmaceutical and chemicals. The inventors were granted only EMR, exclusive marketing rights. In India, patent system is administered under the superintendence of the Controller General of Patents, Designs, Trademarks and Geographical Indications. The functioning of Patent Office and Patent Information System is directed by the Controller General. The statutory duties like granting patent for new inventions etc. is performed by Patent Office. The head office of patent is located at Kolkata and 3 other branches are located at Mumbai, Chennai and Delhi. The duty of branches is to deal with the applications of patents corresponding to their territorial jurisdiction. The patent related information and specification is maintained by Patent Information System and also provides technological information to various users such as R&D establishments, government office, private industries, business and inventors. Next, legal aspects related to patents. The main provisions of the Patent Act are as follows. The Controller General of Patent, Designs and Trademarks appointed under the Trade and Merchandise Marks Act 1958 shall be the Controller of Patents. For the registration of patent, Patent Office is maintained. A register of patent is kept at Patent Office which includes following: the names and addresses of grantees of patents, notifications of assignments, extensions and revocations of patents and particulars of such other matters affecting the validity or proprietorship of patents as may be prescribed. An application for a patent for an invention may be made by any of the following persons. By any person claiming to be the true and first inventor of the invention. By any person being the assignee of the person claiming to be the true and first inventor in respect of the right to make such an application. By the legal representative of any deceased person who immediately before his death was entitled to make such an application. The following are not inventions within the meaning of Patent Act. An invention which is frivolous or which claims anything obvious contrary to well-established natural laws. An invention, the primary or intended use of which would be contrary to law or morality or injurious to public health. The mere discovery of a scientific principle or the formulation of an abstract theory. The mere discovery of any new property of new use for a known substance or of the mere use of a known process, machine or apparatus unless such known process results in a new product or employs at least one new reactant. A substance obtained by a mere admixture resulting only in the aggregation of the properties of the components thereof or a process for producing such substance. The mere arrangement or rearrangement or duplication of known devices, each functioning independently of one another in a known way. A method or process of testing applicable during the process of manufacture for rendering the machine, apparatus or other equipment more efficient or for the improvement or restoration of the existing machine, apparatus or other equipment or for the improvement or control of manufacture. A method of agriculture or horticulture. Any process for the medicinal, surgical, curative, prophylactic or other treatment of human beings or any process for a similar treatment of animals or plants to render them free of device or to increase their economic value or that of their products. One single application is to be given for one invention and shall be made in the prescribed form and filled in the patent office. Every application shall state that the applicant is in possession of the invention and shall name the owner claiming to be the true and first inventor. And where the person so claiming is not the applicant or one of the applicants, the application shall contain a declaration that the applicant believes the person so named to be the true and first inventor. Every such application shall be accompanied by a provisional or a complete specification. Where an application for a patent not being a convention application is accompanied by a provisional specification, a complete specification shall be filed within 12 months from the date of filing of the application. And if the complete specification is not so filled, the application shall be deemed to be abandoned. Every complete specification shall fully and particularly describe the invention and its operation or use and the method by which it is to be performed, disclose the best method of performing the invention which is known to the applicant and for which he is entitled to claim protection, and end with the claim or claims defining the scope of the invention for which protection is claimed. At any time within 4 months from the date of advertisement of the acceptance of a complete specification under this Act or within such further period not exceeding 1 month in the aggregate as the controller may allow on application made to him in the prescribed manner before the expiry of the 4 months aforesaid. Any person interested may give notice to the controller of opposition to the grant of the patent on any of the following grounds, namely, that the applicant for the patent or the person under or through whom he claims wrongfully obtained the invention or any part thereof from him or from a person under or through whom he claims. Next, that the invention so far as claimed in any claim of the complete specification has been published before the priority date of the claim. First, in any specification filed in pursuance of an application for a patent made in India on or after the first day of January 1912, or second, in India or elsewhere in any other document. That the invention so far as claimed in any claim of the complete specification is claimed in a claim of a complete specification published on or after the priority date of the applicant's claim and filed in pursuance of an application for a patent in India, being a claim of which the priority date is earlier than that of the applicant's claim. That the invention so far as claimed in any claim of the complete specification was publicly known or publicly used in India before the priority date of that claim. That the invention so far as claimed in any claim of the complete specification is obvious and clearly does not involve any inventive step. That the subject of any claim of the complete specification is not an invention within the meaning of this Act or is not patentable under this Act. That the complete specification does not sufficiently and clearly describe the invention or the method by which it is to be performed. That in the case of a convention application, the application was not made within 12 months from the date of the first application for protection of the invention made in a convention country by the applicant or a person from whom he derives title, etc. Where any such notice of opposition is duly given, the controller shall notify the applicant and shall give to the applicant and the opponent an opportunity to be heard before deciding the case. Where a complete specification in pursuance of an application for a patent has been accepted and either: first, the application has not been opposed and the time for the filing of the opposition has expired, or second, the application has been opposed and the opposition has been finally decided in favor of the applicant, or third, the application has not been refused by the controller by virtue of any power vested in him by this Act. Then the patent shall, on request made by the applicant in the prescribed form, be guaranteed to the applicant, or in the case of a joint application, to the applicants jointly, and the controller shall cause the patent to be sealed with the seal of the Patent Office, and the date on which the patent is sealed shall be entered in the register. The term of every patent granted and the term of every patent which has not been expired and has not ceased to have effect under this Act shall be 20 years from the date of filing of the application for the patent. Where an application is made for a patent in respect of any improvement in or modification of an invention described or disclosed in the complete specification filed thereof, and the applicant also applies or has applied for a patent for that invention or is the patentee in respect thereof, the controller may, if the applicant so request, grant the patent for the improvement or modification as a patent of addition. A patent of addition shall be granted for a term equal to that of the patent for the main invention. At any time after the expiry of 3 years from the date of the sealing of a patent, any person interested may make an application to the controller alleging that the reasonable requirements of the public with respect to the patented invention have not been satisfied, or that the patented invention is not available to the public at a reasonable price, and paying for the grant of a compulsory license to work the patented invention. If any person fails to comply with any direction given under the Act or makes or causes to be made an application for the grant of a patent in contravention of the Act, he shall be punishable with imprisonment or with fine or with both. Let us learn about the technology transfer. To understand The concept of technology transfer, a brief description of technology, can also be given. In the words of Kumar et al., 1999, technology consists of two primary components. First, a physical component which comprises of items such as products, tooling, equipments, blueprints, techniques and processes. And second, the informational component which consists of know-how in management, marketing, production, quality control, reliability, skilled labor and functional areas. It can be easily found that technology used in developed countries is different from developing countries. But developing countries need updated and advanced technology for faster economic development. In an era where world has become global village, product of each and every country, whether developed or developing, is competing with each other. In this kind of scenario, it becomes more important for the developing country to make technically sound product that face competition from developed countries. This situation creates scenario for technology transfer. UNCTAD has requested to developed nations to transfer technology to developing nations. In simple words, technology transfer is a price by which commercial technology is transferred by one proprietor or firm to another firm. This transfer can take place between following: developed and developing, next developed and developed, next developing and developing. In the words of WIPO, the dissemination and transfer of technology is major pillar support the raison d'etre of the patent system. Patent gives an exclusive right to improve the efficient flow of knowledge and also facilitate to protect the technology. It is a legal framework that gives a platform to all technology holders to present their inventions to general public and also provide them an opportunity to sell their patent. The process of technology transfer is complex and a number of factors like political, market, human resources, etc. affects process of technology transfer. Any conflict with the economic and social needs of recipient country will affect the success of technology transfer. For instance, in 1960s, the agriculture development of northeastern Brazil has mainly financed by international banks or financial organizations. But much of this region had been inhabited by Brazilian aborigines, but in the tropical rainforest area like Amazon, imported technology caused serious environmental damages such as soil erosion and also resulted in the destruction of natural environment of birds and animals. So, it is imperative to check the suitability of technology and its expected effects of different factors before actually starting the process of technology transfer. So, it is to be understood that technology transfer concept is not only a matter of concern about the transfer of technological knowledge or information, but also the capability of technology recipients to learn and absorb technology into the production function. Thus, 1987 argues and explains that technology transfer can be of two types. First, production of new product or embodied technology transfer. Second, more efficient production of existing products, process or disembodied technology transfer. As described by Levin 1993, in the social science perspective, technology transfer is a socio-technical process implying the transfer of cultural skills accompanying the movement of machinery, equipment and tools. Next is types of technology transfer. Broadly, transfer of technology can be of two types. First, internalized technology transfer. Second, externalized technology transfer. Internalized technology transfer. It is in the form of equity participation, FDI, etc. Contribution of capital should be more than 50%. It provides capital as well as technology. Technology flows from one foreign unit to a unit situated in another country with full or partial control over technology. For example, when an MNC set up a subsidiary in a developing country and transfers technology to its subsidiaries. Next is externalized technology transfer. It can be in the form of licensing agreement or equity also, but contribution of capital should be less than 50%. It provides only technological knowledge. Technology flow from transferor to transferee with no control over the technology. For example, cases of license agreements or joint ventures have increased among countries, especially due to government interventions and restrictions on FDI, etc. Next is the levels of technology transfer. First, operational level. It is the least possible level of technology transfer. It may take place in the forms like manufacturing skills, maintenance, procurement or quality control. Next, duplicate level. Next level in the technology transfer can be duplicate level, where investment are also made to increase the level of capacities and to purchase and integrate foreign technologies. Next, adaptive level. This level is a level of self-reliance where imported technologies are adapted and improved according to the requirements of locals. And the last is innovative level. This level of technology transfer is symbol of innovative skills and based on well-established R&D, which is an essential to generate new technologies. Next is types of technology transfer agreement. A. License agreement. A license agreement is one of the most detailed agreements of the technology transfer. The license agreement includes following: legal names of both institutions, the definitions of all the terms used, the effective date of agreement, the termination date of agreement, specific technology being transferred, amount to be paid by licensee for the technology. B. Training to employees. Knowledge of simple and unpatented techniques or production process can be transferred by imparting training to personnel. C. Turnkey contract. Route of turnkey project is normally taken to transfer complex technologies. Apart from supply of goods, it includes design, creation, commissioning or supervision of a system to client. D. Contract for the sale of plant and machinery. It provides for the transfer of operational technology pertaining to plant and machinery being transferred. Role of technology transfer in economic development. As per an old proverb, give a man a fish and you feed him for a day. Give a man a fishing rod and he feeds himself and his family for as long as the rod lasts. But a new take on this old proverb can be: help a man develop the knowledge and means to improve the fishing rod and to design and produce new ones, and he may feed himself and the societies for years to come. This new adaptation of old proverb given by WIPO clearly explains the role of technology transfer in the economic development of a country. There is a huge technological gap between the rich and poor countries, and the main reason behind this gap is economic distance between these two areas, as pointed out by Lord Snow in his The Two Cultures and A Second Look. The improvement in the level of living in the developing countries does not require any major new scientific discoveries. The accumulated knowledge is sufficient to accomplish this task. What it needed is to ensure its transfer to the needy. In the 19th century, when process of industrialization begins, each new nation which started industrialization process either bought, borrowed or stole the technical knowledge. As a result of such transfer, the overall growth rate of world was progressive. So, transfer of technology performs central role in the development of nations. Development of a country depends upon the goods and services produced, which in turn depend on the available technology. It is imperative for every country to use best and updated technology to maintain the pace of growth. If a country can't innovate or produce technology itself, in that case, technology transfer can play a very important role. Let us now recapitulate what we have learned so far. The economies of the present day world are driven by scientific research and technology. In India, institutions such as CSIR, ICAR, ICMR, DRDO, DAE, etc. have been established to conduct research activities. The objective of science and technology policy is to achieve coordination between industry and specific research and to encourage the transfer of technology and know-how generated by scientists and technologists to industry. Businesses having well-established R&D infrastructure and strategies have a better chance of success as compared to businesses that don't. A good and powerful R&D strategy, R&D strategy can lead to innovation and increased productivity and can boost your company's competitive advantage. Patent gives an exclusive right to the manufacturer of article product for a limited period. In India, patent system is administered under the superintendence of the Controller General of Patents, Designs, Trademarks and Geographical Indications. Technology used in developed countries is different from developing countries, but developing countries need updated and advanced technology for faster economic development. Patent gives an exclusive right to improve the efficient flow of knowledge and also facilitate to protect the technology. Patent is a legal framework that gives a platform to all technology holders to present their inventions to general public and also provide them an opportunity to sell their patent. There can be two types of technology transfer: internalized technology transfer and externalized technology transfer. Level of technology can be operational, duplicate, adaptive and innovative. Technology can be transferred through agreements like license, training to employees, turnkey contract and sale of plant and machinery. Transfer of technology performs central role in the development of nations. Development of a country depends upon the goods and service produced, which in turn depend on the available technology. Thank you.